Hi everyone, today we're going to be talking about navigating the PERM labor certification process. My name is Ruby Powers. I'm board certified immigration attorney. We're going to be talking about a process that not a lot of people understand, and sometimes people say want to get sponsored or things like that. And so we're going to go ahead and explain that this is how an employer can, if you will, maybe sponsor or create when they have a labor shortage and they cannot find someone to do the specific job, they test the labor market and find an individual who is capable of doing so with the prevailing wage and can they can in the end obtain a legal permanent residency for the employee. It was created by the Department of Labor in March 2005, and it's now, we call it the Program Electronic Review Management, which we just call PERM. And so that's what, when we say PERM, that's what it means. And so the objective is to protect the U.S. workers and be cognizant of the job market and making sure that the available jobs are could otherwise be filled by qualified U.S. workers. And all right. And so why does the application process seem so complex? Well, before the PERM system, labor certifications involved working with the Department of Labor and various related state agencies in every step of the process. And there's a lot of processing times and they didn't have adequate resources. But now this has been streamlined to cut down on the overall time. And then at the end, applicants can have legal permanent residency by applying through USCIS or through the Department of State. So when we're talking about here, individuals can obtain legal permanent residency through employment-based options through different ways. And when we're talking here, where there's either the EB-2, the EB-3, or also the other categories like other workers and things like that, which is the EB-3. And so some of these are mandatory. So EB-2 PERM is required unless it's a national interest waiver, and then EB-3 for most other for the skilled professional and other workers. So most of them fall under EB-2 and EB-3, and we can continue. So the requirements are you must have a permanent job offer from a lawful U.S. employer. The wage package offered to the applicant must be equal or above the prevailing wage for the position as specified by the Department of Labor. The local job market must have been properly analyzed for qualified U.S. candidates, so no available U.S. worker could fulfill that position. USCIS must ask for supplementary documentation relating to the employer's recruiting efforts, and the U.S. employer must prepare and maintain an audit file with proof of attempts to recruit. Applicant must demonstrate the uniqueness of his or her exceptional skills and cannot be duplicated by a qualified U.S. worker. So the prevailing wage determination is really critical to ensure fair wages, and it helps protect U.S. workers. It's issued by the Department of Labor. The employer submits the ETA 9141 to request the prevailing wage determination, and then the wage is based upon occupation, the location, and the level of experience. There's different tiers. Can take between 5 to 6 months to receive that determination. And then the wage offered in the job must meet or exceed that DOL, Department of Labor rate. So once that wage comes back, the employer has to agree to pay that or above that amount. If there's an underpayment, can lead to a denial or an audit. And this job titles are very critical. Sometimes people use different job titles. They think they're being creative, but it's very specific and it's important to know this space in Department of Labor and also the descriptions. So some of the reasons why PERM processes might be denied: inadequate recruitment documentation, which is like when you post the position and if other individuals apply, you need to be able to document who those individuals are and what happens if they met the qualifications or not. You have to give, and if they've been disqualified, then you need to be able to explain that. Yeah, if the employer offers less than the prevailing wage, that can also disqualify the case. Improper job descriptions, Unrealistic qualifications can raise flags like speaking gazillions of languages or having this much education, but at the same time, if those truly are needed, then that makes sense. But unrealistic qualifications are something to keep an eye on. Failure to properly test the labor market and meet the deadlines is very, very formulaic and deadline specific. And then if there's inconsistencies between the job ads and the ETA 9089 supporting documents, it's very, very specific. And then the employer and attorneys must work closely to meet all the regulatory criteria. The required documents for applications include that prevailing wage request, which can take that 5 to 6 months, the job order documentation with a clear outline of the job details, the proof of the newspaper ads and notice of filing plus 3 alternate recruitment efforts for professional occupations, and the completed Form ETA 9089. So what does it look like? What does the employer have to do? They have to post a notice of filing at the work site for 10 business days. Then they have to place 2 Sunday newspaper ads in a major paper where the job is located. Then they must submit a statewide workforce agency job order. And then for professional roles, there's an additional step of 3 additional recruitment steps like job fairs, employer's website, trade publications, or campus recruitment. Now, keep a recruitment record documenting the results and why the U.S. applicants were not qualified, if that is the case. And the ads must list the job duties, requirements, location, and wage. Now, here's some just idea of what the processing times could be. Employer preparation, working on the title and the job description, obtaining the prevailing wage, which we said could be 5 to 6 months. Prevailing wage determination process here, conducting the good faith certification, and then receiving the Department of Labor's decision on the PERM application. Filing the I-140 visa petition is not that timely, especially if you do the premium processing, which you can get about 15 calendar days. But if you don't pay for premium processing, it could take 4 to 12 months. And then there's the adjustment of status, which can differ greatly depending on what's going on with the processing times, but also because of the visa availability, depending on where you are. So the processing times fluctuate due to Department of Labor backlogs and staffing. Prevailing wage determinations can average 5 to 6 months. The PERM adjudication can take 9 to 11 months from filing. There's the audit request, which it could happen, it might not, but it could. Using the Department of Labor flag system to check real time is ideal to see what's going on at that moment. Premium processing is not available for PERM itself, but it is available for the I-140, like we mentioned. And planning ahead and tracking timelines can help avoid employment disruptions. Now, what happens after the PERM approval? Well, after the PERM is certified, the next step is to file that I-140. And you have to file it within 180 days of the PERM approval, so around 6 months, right? The employer must prove ability to pay the offered wage and include the full PERM mock documentation with the I-140. Once the I-140 is approved, the employee can file the 45 when the visa priority date is current, or if they have to, they can do consular processing. The I-140 can be filed via premium processing with additional fee to get that results within those 15 calendar days. If the employee is abroad, they'll complete consular processing instead of the I-45. So the legal fees and filing fees and all these different fees can differ greatly depending on lots of factors. There's no fee to file the ETA 9089. Legal fees can differ. Employers must pay the required recruitment ads like newspaper ads, state job postings, and trade journal, job board, or radio ads, fairs, things like that. There could also be other costs like translation, evaluation of foreign degrees, and the employers, not the employees, must pay all the PERM-related recruitment costs to comply with the Department of Labor rules. STEM professionals are in demand and often benefit from a faster path through PERM or waivers. The STEM roles may qualify maybe for the EB-2, which is the national interest waiver, where you're waiving the need to do the labor certification. That's where the waiver part comes from. And actually, a national interest waiver does not require a job offer either. But if you're not using the national interest waiver, the employers must use the full PERM process. And then the Department of Labor may scrutinize that experience requirements for high skilled roles, ensure job requirements are not tailored to the beneficiary, and highlight how the foreign national adds unique value or innovation to the role. Make sure to start early, define the job duties and minimum requirements, document all the steps, avoid overly restricted qualifications, double check the titles and duties match everywhere along the way, and make sure that you have organized audit files in case there is a audit or need further review. It's definitely important to work with closely with an experienced immigration law firm in the PERM process. And like we mentioned, there are cases when you can have the PERM labor certification waiver where you don't need to do the PERM process. And here are some examples, like we mentioned, national interest waiver, EB-4, EB-5. So this is overall the process. It can be quite timely, but it can be beneficial in the end to obtain legal permanent residency through that sponsorship through your employer. It does take coordination between the employer and the employee and the law firm throughout the process. And so if you'd like to hear more, or you can always give us a call at 713-589-2085 and reach out to us on rubypowerslaw.com. We're available on all these different social media platforms. And this is our perm labor certification for the beginning of August. And we're going to have other topics about preparing for credible fear interview, consequences of circumventing legal immigration, circumventing legal lawful pathways, and defending your case in immigration court and VAWA protections. Thank you so much for watching, and we'll see you next time.